Good morning, everyone. My name is Iker Lekuona, and I'm the Director for the International Center for Asset Recovery, Iker, at the Basel Institute on Governance. Many thanks to the organizer, the Office of the United Nations High Commissioner for Human Rights, for the kind invitation. My apologies for not being able to participate in person, and I hope the discussions today are very fruitful. For those of you that are not familiar with Iker, we work globally to strengthen asset recovery capacity, practice, and policy. Iker is currently supporting more than 40 law enforcement, prosecution, and judicial authorities in 19 countries across Africa, Asia, Eastern Europe, and Latin America. Iker supported cases resulted in the recovery of more than $60 million in 2025. I am always enthusiastic about opportunities to speak about the repatriation of funds of illicit origin. This issue is becoming even more relevant in the current geopolitical context. As aid budgets are severely cut, asset recovery becomes more central than ever. The cases discussed here today show how repatriated assets can be reinvested in development programs. But it's worth stressing that effective asset recovery also leads to corruption deterrence. And this deterrence is key to safeguard investments in basic service delivery and poverty alleviation programs. Another global trend is citizen dissatisfaction with corrupt governments. As Gen Z-led protests demonstrate, there is increased citizen pressure from governments to address corruption as a key obstacle to the realization of basic human rights. Regimes are being toppled to dislodge corrupt elites. Recovering the looted assets hidden in offshore jurisdictions is key to restore citizen trust towards the state. Before invoking two examples of asset restitution agreements, I want to stress that asset repatriation is the final step in a complex chain-linked process. The confiscation and the ultimate restitution of illicit assets requires asset recovery systems to work effectively. This aspect is often forgotten in the debates on asset return. FIUs, investigation agencies, prosecution authorities, and the courts all play a key role in detecting, investigating, and prosecuting financial crime, as well as freezing and confiscating illicit assets. At the same time, asset recovery requires international cooperation to work effectively. This is both at the intelligence level, but also through formal mutual legal assistance. We have seen huge progress on technical compliance, but global effectiveness remains weak. Countries tend to have the right legal and policy frameworks. However, the implementation gap is significant, and the volume of recovered assets is low. And I want to briefly turn to two examples of restitution agreements where the assets have been reinvested in strengthening asset recovery systems. The first case concerns Peru, and the second one, Mozambique. In 2020, Switzerland, Luxembourg, and Peru signed a restitution agreement to return $26 million in stolen assets. These illicit assets were stashed in Swiss and Luxembourg bank accounts by former Peruvian President Alberto Fujimori's spy chief, Vladimiro Montesinos, and his accomplices. They were accumulated through systematic bribery and corrupt arms deals during the 1990s. As part of the restitution agreement, the funds are being invested in strengthening the capabilities of the Ministry of Justice, Attorney General's Office, Judiciary, and Special Public Prosecutor's Office to investigate and prosecute organized crime and corruption. The focal point for the agreement and recipient of the funds is Peru's Asset Management Agency. The implementation of the agreement is not without its challenges, but it's leading to increases in the efficiency and effectiveness of the beneficiary agencies. It also incorporates transparency and accountability provisions, such as the publication of annual reports by the beneficiary agencies and audits by the National Supreme Audit Institution. The Mozambique example refers to the restitution of more than 800,000 British pounds by Jersey, the British Crown dependency. In this case, the proceeds of corruption were hidden by a civil servant in an offshore trust. As part of the agreement, Jersey and Mozambique decided to reinvest part of the funds to strengthen the recently created Asset Recovery Office. In both instances, restituted funds are having a multiplier effect. Investing in asset recovery systems is key to dissuade further acts of corruption, increase the volume of assets that are recovered, and ultimately realize basic human rights.